Does Congress have the legal power to regulate presidential elections? The answer is no. Yet Senators Angus King, Amy Klobuchar, and Dick Durbin have released a discussion draft of their legislation to place Congress in control of the presidential election process in direct violation of the Constitution of the United States. Let's look at this blatant act of theft in the light of what the Constitution actually says. Then we can decide how to deal with these oath breakers.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans, and welcome to the Constitution Study. This is where we read and study the Constitution. We teach a rising generation to be free. I'm glad you could join me. If you want to help support the work that we're doing, please go to constitutionstudy.com. You'll find a donation page. You can help us financially, or you can help us by spreading the news, spreading the word, taking the articles, the video, the audio, sharing it with friends, family, neighbors, sharing it on social media. Let other people know there are ways that they can read and study the Constitution for themselves. Now, I'll talk a little bit more about the website at the end of the video, but for now, let's talk about this Modernized Electoral Count Act. From the announcement of the Modernized Electoral Count Act, following months of research and consultation with outside experts and scholars, senators share a proposal to address ambiguities in 1887 law. The first question anyone should ask when considering a piece of legislation is it constitutional? Meaning, is it enacting a power delegated to that government, or is it prohibited by the Constitution? So let's look at the power this legislation claims to exercise and see if it's constitutional or not. To amend Title III, United States Code, to revise the rules for presidential elections and counting electoral votes, and for other purposes. The legislation claims the power to revise the rules for two things: presidential elections and counting electoral votes. The first question we must ask is, does the Constitution delegate to Congress the power to regulate presidential elections? Well, from the draft legislation, under the section Revision of Rules Relating to Presidential Elections, we read, in general, Chapter 1 of Title III United States Code is amended by striking sections 1 and 2 and inserting the following. Under time of choosing electors, in general, the time of choosing electors of president and vice president shall be, in each state, election day. Under prohibition on using alternate dates, we read, no state may establish any day other than election day as the time for choosing electors of president and vice president. The first change this legislation would make is to the time of choosing electors. Now, this is a power delegated to Congress from Article 2, Section 1, Clause 4 of the Constitution. The Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. From there on, the legislation attempts to regulate the manner in which presidential electors are chosen. Popular elections. In general, in the case of a state that chooses electors by popular election, the last day on which popular ballots may be cast in such election shall be election day. Now, that power, however, is specifically given to the state legislatures in Article 2, Section 1, Clause 2 of that Constitution. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which a state may be entitled in the Congress. Now, the proposed legislation goes on to allow states to establish by law how to treat ballots, allow for mail-in ballots, deal with those waiting to cast ballots when the polls close, etc. The law even allows the states to set rules for resolving whether a ballot was filled out and submitted on time, as long as it complies with federal law. This legislation would establish a procedure for extending the time of voting under certain conditions, such as catastrophic events, major disasters, or acts of terrorism. The legislation would even establish a criminal penalty for anyone causing a catastrophic event to extend the time for voting. This legislation would also allow states to provide alternative electors, as long as they did so by election day. These electors would be the only ones allowed to fill in any vacancies that may happen before the electors vote. This legislation would establish a standard for making the final determination of the appointment of electors, such determination to be final and conclusive. This final determination is to be certified by the state officials responsible for the duty or by the judgment of a federal court. Now, if a state does not reach a final decision by the deadline required by this legislation, any candidates for president or vice president can bring a civil action seeking a declaratory judgment in federal court. This legislation even claims the power to bind a state's governor. Under final determination binding of governor, for the purpose of the duties of the governor set out in Section 6, a final determination of the appointment of electors by a state under this section shall be conclusive, and the only names of electors contained in the certificates of identification of electors that are transmitted under this section. If any state official purports to discharge the duties set out in Section 6 in a manner inconsistent with this subsection, such action shall be void and without legal effect, and no state official or purported elector may certify or transmit to any official listed in Sections 6 or 11 any purported certificate of identification of electors contrary to the final determination, and any action by a state official or purported elector certifying or transmitting such certificate contrary to the final determination shall be void and without legal effect. Now, how nice of Congress. There's just one little problem. Because none of this is authorized by the Constitution of the United States. Now, since establishing rules for choosing presidential electors is not a power delegated to the United States by the Constitution, that power remains with the states. From the 10th Amendment, the powers not delegated to the United States by the Constitution, nor prohibited by to the states, are reserved to the states respectively or to the people. This legislation then goes on to create a whole new set of rules for the issuance and transmission of the certificates of those chosen to be electors. See, again, under duties of the governor, we see issuance of certificates of identification of electors. The governor of each state shall issue 14 duplicate original certificates of identification of electors as described in paragraph 2. Transmit such duplicate original certificates of identification of electors as provided in paragraph 3, and make publicly available on the website maintained by the governor a copy of such duplicate original of the certificate of identification of electors. There is no requirement in the Constitution for the states to tell Congress who has been chosen as elector. It's none of their business. To make matters worse, should a governor fulfill their oath to support the constitutions of their state and the United States and ignore these illegal rules, Congress proposes to take the power to determine the slate of electors out of the hands of the duly elected officials of the state and place it in the hands of the federal courts. In general, if the governor of a state fails to execute the duties under this subsection by the date applicable under paragraph 3b, the chief state election official of the state shall execute such duties within 1 day of the governor's failure. Failure by chief state elections official. If the governor fails to execute the duties under this subsection by the date applicable under paragraph 3b, and the chief state election official fails to execute the duties under subparagraph a, then any candidate for president or vice president on the ballot in the state may bring an action in the federal district court of the district in which the state capital of the state whose determination is at issue is located, or the federal district court for the District of Columbia, seeking declaratory, injunctive, or other appropriate equitable relief to ensure the identity of the electors listed on the certificate of identification reflects a final determination under Section 5. Any judgment in such action, if neither stayed nor modified on appeal, shall be treated for purposes of this chapter in the same manner as a certificate of identification of electors issued under this section, and the court shall direct the preparation and transmission of, or itself prepare and transmit, any document required to effectuate the judgment. Nowhere in the Constitution is Congress delegated the authority to determine the handling of election certificates before they are even delivered. Yet this legislation creates an extended set of rules for the electors to deliver their votes. It would require 7 duplicate original certificates with the list of voters for president and vice president, adding an outer envelope with a copy of the certificate, and continuing the illegal practice of sending copies of the certificates not only to the president of the Senate as required by the Constitution, but to the Speaker of the House and the Secretary of State and the Chief Justice of the Supreme Court. All in direct violation of the process required by the 12th Amendment. And they shall make distinct lists of all persons voted for as president, and of all persons voted for as vice president, and of the number of votes for each, which list they shall sign and certify and transmit sealed to the seat of the government of the United States directed to the President of the Senate. Not only would this legislation unlawfully regulate the appointment of presidential electors, it ignores the Constitution regarding the counting of their votes. Under presiding officer, in general, except as provided in subparagraph B, the President pro tempore of the Senate shall be the presiding officer at the joint meeting of the Senate and House of Representatives referred to in paragraph 1. Subsection 1, presentation of electoral certificates. In the alphabetical order of the states, the Secretary of the Senate shall open in the presence of the tellers the outer envelope containing for a state the certificate of identification of electors and the sealed certificate of votes provided to the President of the Senate under Section 11, and shall make a preliminary determination that the state has submitted its list of electors, which list shall have been previously made available to the members of the Senate and the House of Representatives. That's incorrect, because the 12th Amendment clearly states the role of opening the certificates and having them counted belongs to the President of the Senate, who is the sitting Vice President. From the 12th Amendment, the President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the vote shall then be counted. Furthermore, there is nothing in the Constitution about making these certificates available to members of Congress before they are opened in a joint session for a preliminary determination by the Secretary of the Senate. This legislation changes the process for objections to be heard, something that is part of our current federal law and, by the way, not in the Constitution. Under call for objections. After the Secretary of the Senate has made the preliminary determination under paragraph 1, with respect to a state, the presiding officer shall call for objections to the validity of the certificate of identification of electors of such state. As a final finger in the eye to the Constitution and, in fact, representative government itself, this legislation claims the power to determine what to do should no decision be made in time for the inauguration. If the administrator has not made the announcement under paragraph 1 by the third Tuesday after Election Day, as defined in Section 21 of Title III, United States Code, the administrator shall, for purposes of this act, treat as president-elect the two candidates for president with the most pledged votes of electors of present based on certifications by state of their final canvass, and treat as vice president-elect the two candidates for vice president with the most pledged votes of electors of vice president based on certifications by state of their final canvass. Now, compare that to what the Constitution actually says. If a president shall not have been chosen before the time fixed for the beginning of his term, or if the president-elect shall have failed to qualify, then the vice president-elect shall act as president until a president shall have qualified. And the Congress may, by law, provide for the case wherein neither a president-elect nor a vice president-elect shall have qualified, declaring who shall then act as president, or the manner in which one who is act shall be selected, and such person shall act accordingly until a president or vice president shall have qualified. See, Congress doesn't get to decide who acts as president unless both the president-elect and the vice president-elect have yet to be decided by Inauguration Day. In that case, the law is to determine who is to act as president, not establish a committee for the presidency or vice presidency. Now, my guess is few of you have heard about this proposed legislation. It is yet another example of the corruption, lawlessness, and unfaithfulness to their oath that so many in Congress display. If those in Congress are so ignorant, reckless, and corrupt, why do we keep hiring them to serve us? As President James A. Garfield said, "Now more than ever before, the people are responsible for the character of their Congress. If that body be ignorant, reckless, and corrupt, it is because the people tolerate ignorance, recklessness, and corruption. If it be intelligent, brave, and pure, it is because the people demand these high qualities to represent them in the national legislature." It appears most of the American people are willing to tolerate ignorance, recklessness, and corruption. That means that this abuse of the Constitution, the experiment in self-government, and the consent of the governed is ultimately our fault. The question is, will the American people do anything to stop it before it becomes law? Have you heard about this legislation? Did you look at it and say, maybe there's some not half bad ideas in there? But the question is Is this a power of Congress? We already see Congress trying to take over elections for House and Senate. And by doing so, actually take over all elections as a whole. They want to nationalize the process. Now they want to do the same thing for presidential electors. This is in direct violation of the Constitution, the consent of the governed, yet it is moving forward. I don't know if this is going to become law or not, but what I do know is that the American people need to stand up and push back on their servants in government. Tell them, no, this is illegal, this is unconstitutional, this is an abomination of your oath of office. If you don't realize that Congress isn't in charge of electing the president, you're not smart enough to represent us. If you have no clue what the Constitution says that you took an oath to support, to quote another podcaster, you're crippled too high for crutches. This is basic stuff. This is simple stuff. Every 4 years we go through this, yet it doesn't matter. At least not to these 3 senators. Doesn't matter to you. Now, if you learned something from this episode, find out more. Go to constitutionstudy.com. You can find the articles, the video, the podcast, links to my radio program. All of it's there. All of it's for you to share. All of it's for you to use. And it's all free of charge. Sure, you could support me by donating to the Constitution Study, or you could just share this information. You can ask a question, you can sign up for a newsletter. Hey, you could join us in our Constitution Study. There's still one free meeting left. Even if you don't join the free live meetings, you can find the recordings on constitutionscholars.com. Simply sign up for your free account, and under the classrooms, you'll find the Constitution Study, and you can take the Bill of Rights section absolutely free. But let's educate ourselves. Let's recognize when our right to consent to the governed is being violated, and then figure out how we can defend it, how we can assert our rights, and do so legally, constitutionally, rather than these criminals that are currently running loose in our national legislature. And if we do that, maybe, just maybe, America will continue to be the land of the free and the home of the brave. And hopefully you'll join me here next time for the Constitution Study.
There's one